Welcome to Sportico's interview with Paul McDonald, who is a lead attorney in Johnson versus NCAA, a case that is currently before the U.S. Court of Appeals for the Third Circuit. Paul is a graduate of Princeton University and New York University School of Law. He has practiced at very prestigious international law firms, including Kirkland and Ellis and Paul Hastings. He's also worked for Kraft Foods and Valorum Law Group, and he's been a leader on American Bar Association committees. And now he's on the cusp of shaking things up in college sports with a case that argues that college athletes are student employees as much as, and arguably more so, than fellow students who are employed in work-study programs, including work-study students who have scholarships. So welcome, Paul. Thank you for spending a little time with us. My first question is, how did you get involved with this case?
First of all, thanks for having me. It's kind of a funny thing. My dad and I were having a conversation. This is back in probably, 2013, 2014, around the whole Johnny football question about athletes, student athletes being paid. And, we were sitting there talking about it, and it occurred to us that the NCAA has always told this story that they can't be both students and employees. But my dad, who worked when he was in college, University of Texas, was like, wait a second. I was a student and an employee at the same time. And we're like, yeah, and there are other students who are also employees, who are both at the same time. Whether you're talking about a dining hall or a bookstore, a library, and of course, even the kids that work at the games, selling you popcorn are paid on an hourly basis. And then you do a little bit of digging and you realize that the student athletes have timesheets just like the fellow students who are being paid hourly by the university. And then you just go further and you say, okay, well, what makes these other students employees? And if you look at that criteria and you start applying it to student athletes, how do they stack up? And it's kind of obvious when you start thinking about it. The student athletes are, as you indicated in the introduction, certainly as much employees as the fellow students, and arguably considerably more. And that's what our complaint, especially the second amended complaint, which I can make sure you have a copy of if you want to post it with the interview. Folks can go through, and what we do, there's two different tests, employee tests that we utilize. One is specifically a student employee test that was articulated in a case called Glatt v. Fox Searchlight. The other is kind of an independent contractor test. But either way, if you look at either test, you go through each criteria and you start comparing student athletes to work study students using federal regulations to different admissions that the NCAA and other schools have made in other cases. It becomes clear the student athletes meet these criteria.
Yeah, and building on that, we've seen other efforts to have college athletes recognized as employees. We've seen various arguments from economists and attorneys that college athletes should be paid their fair market value. When Zion Williamson played at Duke for a year, what was his value to Duke given increase in attention for the school, TV ratings and the like, merchandise sales? You might say he was worth $1 million, maybe more, to Duke. Your case doesn't argue that it's unlawful for Duke to not be able to pay Zion Williamson $1 million. Your ask, you might say, is more modest in that you're saying this is about at least treating college athletes the same as students that, and let me read from your complaint, student ticket takers, seating attendants, and food concession workers at games. They're paid on a minimum wage scale from about $10.50 to $13.50 under work study. Am I right to say your case is saying they should at least get that?
Yeah, that's exactly correct. I mean, our case doesn't say the student athletes shouldn't be paid more, quite the opposite. I think it's kind of obvious that of the students on campus, and considering what the student athletes bring to the campus, not just in terms of revenue, but I think people sometimes take for granted, you identify with your alma mater based upon the sports program, the mascot. I mean, it's everything about how you think about your college experience has some component of sports involved in it. And so there's a value that student athletes bring that other students don't bring. So they certainly should be paid at the higher end of the scale, the minimum wage scale, that we talk about. But it is a matter of just saying, let's just go and establish that they're employees, which, as my dad likes to say, is not even a matter of establishing something new. It's a matter of recognizing something that already is. They are employees when you look at the criteria, when you look at the fact they have timesheets. And so whether or not, how much they actually would end up getting paid, that's a separate issue. We're just trying to establish the bare facts, if you will. And then, how everything else shakes out is something that obviously can be negotiated and figured out. For instance, give an example. Our case doesn't deal with the issue of unionization, because the Fair Labor Standards Act is strictly a pay law, as opposed to the National Labor Relations Act. Should student athletes be able to unionize? I think they should, but that's not our case. And you look at, for instance, at college campuses, you don't see unions of work study students. So there are all kinds of other rights and things that certainly could be discussed. But our case, to your point, is just the bare minimum. It's just not in terms of pay necessarily, but the bare minimum in terms of recognizing something that already, is going on. And the reason why, and one last thing I'll say about that, one of the things that you hear from folks on the other side, and certainly even some of the things that they have tried to say in various briefs in the last couple of weeks to the Third Circuit, is this notion of kind of the sky would fall. And I think what people really need to recognize is ask yourself this question. We've had students who have been work study and other programs working for colleges for decades, and the sky's never fallen. And they will, and to your point about treating student athletes the same, I mean, even my original website was called SAME, Student Athlete Minimum Wage Equity. And the idea was that just treat student athletes the same as you treat other students. And you can't say that if you do that, that somehow there'll be harms that will accrue to student athletes or to the universities when you've never seen it happen to the other students on campus.
Yeah, and building on that, your case is more than just men's basketball players and football players, right? It's
everybody. Right. And that's important because, one of the things that when people talk about the Alston decision last year and Justice Kavanaugh's concurring opinion, one of the things he talks about is, some of the things that are the practical questions that may still need to be resolved. And one of them was the idea of a financially stable way of, paying all the student athletes in compliance with Title IX. That's our case.
Right.
No one can really, with a serious face, argue that paying student athletes on an hourly wage basis, let's say, for instance, you pinned it at $25 an hour. Okay. That would be $2,000 a month during playing and practice season, based upon the NCAA's, 20-hour minimum or maximum, I should say, hours that you're supposed to work to work, a week, right? So, $2,000 a month for 4 to 5 months, playing and practice season. Obviously, you have an off season that has fewer hours that student athletes participate in. I mean, I don't see how anyone can legitimately claim that would somehow bankrupt the universities when every week we hear about another, coach getting an extension, of several $1 million. So it's, the notion the sky would fall is well overstated. And also in terms of implementation, all you would do is take the timesheets that already exist for the NCAA regulations and just fold them into the current system you have for everyone else. Really quite simple.
And there are some who say, well, they have an athletic scholarship. First of all, many don't. But setting that aside, as there are work study students who are working at games that have scholarships too, and they're still getting paid work study.
Yeah. See, what people have to realize is and I'm glad you point that out. Because you have a scholarship. First of all, scholarships, academic or athletic, are treated the same regardless. They're grants and aid. So the IRS treats them the same. The universities treat them the same. So the fact that you might get an academic scholarship, for instance, and then you also go and work for the university in the dining hall or work at a game as a ticket taker. The university can't say that because you have an academic scholarship that they get to then have you work wherever they want you to work and not pay you. It's because the two are unrelated. And it's the same thing here. Having a scholarship, as my dad, again, I refer to my dad a couple of times here because he and I kind of, thought this out together. As he says, all the scholarship does is make you a student, makes you eligible, if you will, to participate in programs offered by the university. One of those programs would be NCAA sports. Another one might be work study, but it doesn't set aside or do anything in terms of saying that the university doesn't have an obligation to then meet its obligations under law to pay you hourly if you do something for them that's non-academic in nature.
Yeah, and building on that. So you mentioned the argument that, well, they're getting something else, so the university doesn't have to pay them or can't pay them. Let's talk about the prisoner analogy, because that comes up in the complaint. And I think it really ties into what you just said. So in the complaint, you write, every time that the NCAA has been required to defend its unlawful policy of refusing to pay student athletes, it has relied heavily on drawing on an offensive analogy between student athletes and prisoners who may be required to work without pay because the 13th Amendment permits involuntary servitude as a punishment for crime. Could you talk about that in the context?
It's interesting. Going back, so I was, involved in the first case, Berger v. NCAA. And in that case, the NCAA started using a legal precedent called Van Skyke v. Peters. It's a Seventh Circuit case. And that case is essentially the seminal case on the issue of prison labor under the 13th Amendment slavery loophole. And people are familiar with the 13th Amendment in large part. I mean, obviously learned about it in school, but in more recent years, people may be familiar with Ava DuVernay's Netflix documentary 13th, which talks about how that particular loophole that says that we abolish slavery and involuntary servitude except as punishment for a crime whereof someone shall have been duly convicted, right? How that contributed to prison boom in the United States. And so what happens with labor law is anytime someone under the FLSA, the Fair Labor Standards Act, when they allege they're an employee who's not being paid, right? They get the benefit of one or two tests, or types of tests. We mentioned this earlier in the conversation. In our complaint, we go through the student employee test. We also deal with the independent contractor versus employee test. So a test like that is always applied when somebody is alleging that they are an employee that should be paid. The only exception to that rule in American jurisprudence is prison labor, because as the court found in Van Skyke v. Peters, even if a prisoner met a test, and they probably do, if you just went down the criterion test, because the 13th Amendment has a specific carve out that says that you can be required to work as involuntary servitude as punishment for crime that you've been convicted of, it doesn't matter. And so what the NCAA has been trying to do throughout this whole process, going back to Berger v. NCAA, is argue that, and then I think it's probably, to me, it's pretty obvious why they're trying to make this argument, because I think they recognize that if a test is applied, they're going to lose this case. Judge Padova and Johnson has already kind of done an analysis to suggest that student athletes, just on a strictly kind of naked analysis, would meet the GLAT test, three in favor, 2 neutral, 2 against. But then one thing he didn't do in his opinion was do the comparison to work-study students, which makes it even more apparent that student athletes meet the criteria. So what the NCAA has been trying to do is avoid a test at all cost. And the only way you can avoid a test is to make this analogy. And so what they used to try to do in a more explicit fashion was suggest somehow that amateurism, a tradition of amateurism, was I guess you would call it a special circumstance on par with the 13th Amendment slavery loophole. And of course, after Alston, amateurism is clearly not in play. It never was, to be clear, because amateurism never was a part of any federal law, never was codified. And then, of course, in Alston, the Supreme Court made it clear that amateurism doesn't exempt you from federal law. But what's interesting is that ever since the Livers case, which is the precursor to Johnson, it's been very apparent from the judge in that case, Judge Bailson, senior district court judge in the Eastern District of Pennsylvania. He said that both Berger v. NCAA and Dawson v. NCAA, he said that they relied heavily, his words, relied heavily on Van Skyke v. Peters. And he said the special circumstance in that case was the 13th Amendment's allowance for involuntary servitude in this circumstance. So what the NCAA has done, they used to be more open about it, and they would actually cite Van Skyke v. Peters. What they've now tried to do, and especially the most recent brief to the Third Circuit, is they'll make references to Berger and Dawson, which again, Judge Bailson's already said relied heavily on Van Skyke v. Peters, and they'll scrub any mention of Van Skyke v. Peters in an effort to not make it as apparent of the offensive analogy they're actually making. It's interesting because, again, if you go into all this kind of the back and forth that they've gone on since Berger, Van Skyke v. Peters is all over this case until until the most recent again, appeals, because they're trying to conceal what they're doing, and they know it. They're very much aware of what they're saying. They're aware that it technically should never have been applied in the first instance. When you go back and read Berger and Dawson, the curious thing is while Van Skyke is mentioned in those opinions, there's no mention of the 13th Amendment's role in the Van Skyke decision. And the reason why is because, again, as they were doing now, the NCAA has always tried to mislead a court. about what it is they're asking them to do.
So, and Judge Padova clearly found what you just said persuasive, right? His ruling was, I mean, it was a slam dunk in favor of saying, in so many words, they're clearly FLSA employees, and that he found really no ambiguity at all
Right.
about this. But you noted that the Ninth Circuit, the Seventh Circuit didn't go for that argument.
Right.
What's your feeling about the Third Circuit?
Well, again, I think what happened in the Seventh and Ninth Circuit. Well, so first of all, the Ninth Circuit case I wasn't involved in at all, and so I can't vouch for the arguments that were made by that plaintiff's counsel. There's some other issues with that case, Dawson. I think, frankly, they sued the wrong entities, whatever. But those are, I wasn't involved in the case, so that's a conversation for them to answer. But Berger, I was the counsel. I was co-counsel initially, and then I was solo counsel by the end of it. So in that situation, again, I think that they didn't actually find anything on a record. I think people should understand this. We've actually never had full discovery in this case. So even I'll talk about what that means for the Padova, Judge Padova opinion you just mentioned. But going back to Berger for a second, what happened is before we got a chance to even go through discovery, the argument was that because Van Skyke v. Peters allegedly would give them the right to say that a test didn't need to be applied, they could dismiss the case. And again, in the Berger decision, if you read through it, there's absolutely no mention that Van Skyke depends upon the 13th Amendment slavery loophole. But if you go back and read Van Skyke itself, it's pretty obvious that it does. So neither of those courts, the Berger court in the Seventh Circuit or the Dawson court in the Ninth Circuit, actually talks about the standard that was applied, the standard that says that we don't have to apply a test. I think it's quite clear that if NCAA counsel had been more candid, or frankly, if folks had paid more attention, I don't think either of those courts would have ruled the way they did, because it's quite obvious Van Skyke doesn't apply here. Now, the reason why I wanted to mention discovery and the fact that there's no factual findings in either of those cases. So there was never a finding that student athletes didn't meet criteria. There was a finding in those cases that no test had to be applied because somehow Van Skyke v. Peters, a case about, again, 13th Amendment slavery loophole, could be applied to student athletes. In the case we're currently in, Johnson, the NCAA, and in front of Judge Padova, he, to your point, he said it's likely the student athletes meet employee criteria. But the thing that's funny about that is that he did that based upon a record that we were able to develop before discovery. So, and the reason why that's important, so we used federal regulations in the complaint, which are indisputable. We used admissions that we were able to get through the Livers case, which again are indisputable, they're admissions. And then the information from the NCAA and the school's websites, which again, indisputable. They're essentially their admissions, even if they're weren't sworn admissions. Their admissions are put out to the public. So if Judge Padova is already saying, based upon what we have now, that it's likely they're employees, it's only going to get worse for the NCAA, which again gets back to why they're so desperate to make an argument that, if it's actually looked at from a legal perspective, is pretty obviously frivolous and also morally offensive. One last thing I'll make about the Third Circuit, since you asked specifically what I think the Third Circuit will do. The Third Circuit has used Van Skyke v. Peters, I think now 15 times, to dismiss claims made by plaintiffs. In each of those times, the plaintiff was a prisoner. and see again, and that's, by the way, that's not unique to the Third Circuit. It's actually consistent across all the circuits. The only two cases in American jurisprudence where Van Skyke v. Peters was cited as a basis for dismissing a claim that was not brought by a prisoner are Berger v. NCAA and Dawson v. NCAA. They're outliers. It's you go through all the circuits and you see repeatedly, whether it's a prisoner bringing a claim under the FLSA, under Title VII, saying I should be paid wages. When the case is dismissed, it's dismissed citing Van Skyke v. Peters and the 13th Amendment, slavery loophole, except for Berger and Dawson.
So, Paul, let's say you win. Let's say the Third Circuit rules for your plaintiffs. What happens next? I assume the NCAA would petition the Supreme Court for review, saying there's a circuit split between Third Circuit and Ninth and Seventh Circuit. If it goes to the Supreme Court, it would seem that at least several of the justices, most notably Justice Kavanaugh, would be receptive to your case. Do you have any kind of sort of crystal ball sense of how this case, if it got there?
Yeah, here's the thing that's kind of interesting. I think, again, and this is, I think, the part that we have to really focus on, because there's no record yet, because we haven't gone through discovery, it really isn't about ruling on the merits.
Hmm.
It's simply about the legal standard that should be applied to a motion to dismiss. To your point, Judge Padova said, okay, the legal standard in every other employee case that's not about prisoners is that we have a test. And if you've alleged enough facts to say that you can meet the test, then you get to go to discovery. That's the standard, for everyone except for prisoners. The NCAA's position is that Berger and Dawson say you don't have to apply a test. So the only question for the Third Circuit right now, in spite of all the other, stuff that's being thrown up against the wall and the briefs that the NCAA and other folks like the Southeastern Conference are filing in this case, the only issue is the appropriate legal standard. Because when the NCAA was given the permission to bring this to the Third Circuit by Judge Padova, their petition and his approval, and even the petition that they then filed to the Third Circuit, did not ask for permission or grant, let alone grant permission, to relitigate the entire motion to dismiss. The only question here is the legal standard. So the question is, does Van Skyke v. Peters apply outside the context of prisoners, as they say it does in Berger and Dawson, or as it quite clearly says on its face, does it not? So, if for some reason they decided, assuming that, again, the Third Circuit rules in our favor based upon its own application of Van Skyke v. Peters, I think it's an open question whether, especially considering I think the Third Circuit would quite rightly point out what Van Skyke v. Peters is actually about. I think it's an open question whether they would actually try to appeal it to the Supreme Court, because at that point, the cat's out of the bag. And let's be very clear, it's not, it's easy for us sometimes to talk about this as lawyers, kind of in a dispassionate fashion, because we say, okay, does this case apply here? Does this case apply here? That kind of thing. It's clear in a legal basis that Van Skyke v. Peters should not be applied to anyone outside the prison context. But then, there's also the court of public opinion. And when it really becomes apparent, the argument that they have been making, comparing student athletes to unpaid prison labor under the 13th Amendment of slavery loophole, it's not sustainable for a host of reasons. And you and I talked about this earlier, and we can talk about it at the very end of the program. That there are other folks who have looked at this who see it through a lens that's problematic. Let's put it that way. So I don't think, I'm not even sure that, frankly, teed up in the fashion of a legal standard for motion to dismiss, that the Supreme Court would even bother to look at it, because it's pretty crystal clear that, again, that legal standard they're trying to argue for only applies to prisoners. But again, what they're trying to do, to your point, they're trying to muddle everything up and trying to argue everything on the merits well before there's ever been any discovery or anything's been done. And I don't think the Third Circuit, because of the limited way in which this appeal was even permitted, is going to fall for that.
If the Third Circuit, through one vehicle or another, recognizes the athletes as employees, FLSA employees, would the NCAA effectively have to recognize athletes in other circuits as employees as well? Because if you're in the Third Circuit and you're right, I mean, it would give a big recruiting advantage to schools in the Third Circuit.
Right. Well, there's two reasons why I think that's true. One is, well, first of all, our case currently, the joint employment allegation against the NCAA is still in play. Right. So if they're ultimately found, if student athletes ultimately found to be jointly employed by the NCAA and the schools they attend, then, technically we win our case. The NCAA is on the hook for making sure that every student athlete is paid. So that would cover everybody, regardless of, what circuit that their school happens to be in. So that's the first thing. The second thing is, I think, as a matter of practicality, the thing is this: I think they have a tough road, because going back to the very kind of beginning of our interview, they're going to, if they continue to go down this path, assuming that we get past, this Third Circuit issue now, which I think we will, because the legal standard is pretty clear that what they're pushing doesn't apply. When you start going through discovery and whatnot, and as I indicated earlier, that it's only going to get worse for them. Ultimately, and this kind of gets back to the movie Philadelphia, with Tom Hanks and Denzel Washington. And you remember this Denzel Washington's character says something to the effect, explain it to me like I'm 6 years old, right? Ultimately, and that's kind of a guiding principle for trial lawyers is, what's the story we're going to have to tell? And in order to try to prevail, they're going to have to try to convince anyone, not just a jury, but judges on appeal, American public, that the kid who again is selling you popcorn at the game, the kid who took your ticket, the kid that told you where to sit at the game, everyone knows they're employees. They would have to convince people that while they're employees, student athletes aren't. And that's just, it's like putting aside the student athletes created the jobs for the other kids at the game, putting aside the student athletes created the jobs for the coaches and everyone else in the athletic department, that they're the one essential, character. That's just kind of something else that's kind of funny. One of the things the NCAA tries to do in their brief, again, it's not a merits issue at this point. They try to make this argument that, oh, they don't meet the criteria because they're not replacing somebody, which is one of the criteria for the GLAT test. It's like, but they're the one essential component to NCAA sports. Without the student athletes, you can't have this industry, right? So when you start looking at the story they would have to tell, if you get past the issue of whether or not a test applies at all, I mean, I guess they could contest it, until the last, dog dies. There's no we say it down here in Texas, but it just seems like it's a road to nowhere, and they're already having a problem, I think, in the public relations. And I think the more people are familiar with this case and what it is we actually are alleging and what the facts already say, I think the more problems they'll have.
And there are a whole bunch of athletes that if you win are owed money.
Yes.
Right.
Yes.
So we can talk for a second about that.
Yeah. And it's not insignificant because, again, depending on if you use the NCAA's 20 hours a week, which, arguably is understating what this, because, you have the goal study that they do, the NCAA does, which shows that the athletes commit, in some sports as much as 40 hours a week. I think all sports, the average is still like 32, regardless of whether you're talking about football or basketball, men's or women's basketball, or you're talking about baseball or the so-called Olympic sports. All the student athletes are contributing a significant amount of time to their sports, whether it's required or encouraged. So yeah, you're talking about a significant amount of money for some folks, especially if you're talking about student athletes who aren't able to go play pro somewhere, or aren't able, or because that's something else I think people need to remember. It's a significant amount of money in terms of what they would be owed, but going back to what we said earlier, it's not a significant amount of money in terms of what the schools would have to pay. People maybe need to be reminded that Todd Gurley was suspended for allegedly getting $3,000 for autographs over a 2-year period. Terrell Pryor and some of his teammates at Ohio State, similar, about $3,000. So what you're talking about is student athletes who just, putting aside what might be covered by the scholarship in terms of academics, they just need some money to do something on the weekends, And right now, their parents, have to send that money to them, as opposed to their fellow students, who are getting paid for the hours they're putting in for non-academic work for the university, whose parents don't have to make that contribution. So yeah, I mean, people are owed money, and people need to recognize that. And it'd be significant to some individuals. It wouldn't be significant, frankly, to the schools in terms of how much they'd have to pay out.
Thank you, Paul. My final question is: there's obviously a lot going on in college sports. There's name, image, likeness. There are efforts before the NLRB to have athletes recognized as employees under the National Labor Relations Act. There are a couple of petitions that have been filed. We know the NLRB General Counsel, Jennifer Abruzzo, has talked about even the phrase student athlete should be considered illegal. I'm wondering how Johnson v. NCAA fits into that, and also voices that you've heard. We talked offline about Reverend Sharpton offering thoughts on this case, and maybe if you could talk about that and others, just sort of where this all fits into the broader story. Right.
Well, Ms. Abruzzo and I actually were on a panel together in February for New York City Bar, their sports law committee. So, very much aware of what she's doing in her space. She's aware of what we're doing in ours. Again, the only main difference, obviously the NLRA covers issues of unionization, which our case doesn't. But our interests are aligned, because I think at the end of the day, both of us, and we had this conversation during that panel, both of us are talking about, standards of control over student athletes. One that when you look at its bottom, when you talk about whether or not someone's an employee or not under the FLSA or under the NLRA, you're talking about the level of control that the alleged employer has over the alleged employee. And it's pretty clear of all the students on campus, the kids who have the most restrictions, who have the most restrictive lives in terms of being controlled by full-time university employees are student athletes. So, so our kind of ways of looking at this, whether from the NLRA and her position or ours FLSA, they certainly kind of dovetail, they come together. Now, again, I think, and also the thing that's interesting about it is, it's, and we talked about this earlier about even the scholarship thing. It's interesting because either the student athletes are either, employees, if you try to do what the NCAA does by implication, right? When they run those ads talking about scholarships and how much, we give scholarships, they're trying to tell people that we're giving them a scholarship, so they're getting something, right? But they're also careful never to say in any lawsuit they're defending against that the scholarship is pay, because they recognize that if they say the scholarship is pay, one, it's not true under the IRS guidelines, it's grant and aid, but two, it would make them employees, right? Which is kind of what when you're dealing with, when you're talking about the Northwestern case, the allegation was the scholarship was pay from the plaintiff's side, so they're employees. Our case, of course, says that they're employees, but they're not being paid. So yeah, there's some similarities, and certainly I think there's some areas also where perhaps we can work together. For instance, with the NLRA requires, as you mentioned, charges to be brought, and they have been brought by various different organizations. But then, in our case, going forward, assuming that we do go forward, we'll be able to get discovery. And I suspect, based upon case law that I'm familiar with in the Third Circuit, that discovery will not be protected because the Third Circuit has a very strong circuit level precedent about what it takes for something to be protected. So frankly, that the NRA and Mr. Bruzzo might be able to piggyback on some of the things that we're doing. So yeah, so I think those efforts come together. And last point you made, yeah, at this point, one of the things that has been a challenge for us so far has been, and I appreciate, for instance, you doing this interview, because you and I had this conversation, is getting folks to understand, one, that our case exists, right? Because we don't have the benefit of Kessler or Berman or Hausfeld, kind of leading the case. So, people who are recognized, and in our case is an antitrust. Antitrust, let's be honest, is sexier, for various reasons in terms of for plaintiffs' lawyers, I think for the treble damages, and also because those cases go after the more explicitly go after TV revenue. Our case doesn't. But the more people get to know about our case and realize what it's about, and also the more they've been exposed to what the NCAA's opposition is, I think we are getting more people who are kind of making statements or making comments in support. And I did have a conversation with Reverend Sharpton on his radio program, Keeping It Real, and he explained to him about our case, as well as the use of Van Skyke v. Peters. And he said that it was a civil rights issue, and that it was offensive, and then it was something that needs to be called out. And I expect and hope that shortly, hopefully, maybe even before you do the write-up on this particular interview, that we'll have a statement from him. I've been talking to his general counsel about that, expressing some concern about the way the NCAA is opposing this case. As you know, Reverend Sharpton has spoken out on the Flores suit against the NFL, which, by the way, my co-counsel, Wigdor LLP, happens to be co-counsel on the Flores case as well. So this is a space that they're well familiar with in terms of fighting for issues that are civil rights based. And then also Reverend Sharpton's made statements on the Sarver investigation conducted by the NBA. So he operates in the space of sports and civil rights where they intersect. And I suspect, I shouldn't say I suspect, I expect, based upon our conversation, which I gave you a copy of the tape from that program, that he'll be making a statement on this shortly.
Paul, thank you so much for spending some time with us.
I appreciate the opportunity, and I appreciate, obviously, the things you've already said about the case, that you have focused in on it, because I think it is, it's not the end of the road, certainly, even if we prevail from the standpoint of where this issue goes. I think unionization and all those other things will still have to be sussed out. But I think it is a significant step towards it, as we said earlier, at least establishing, as a core, that they are employees just like their fellow students who are working hourly and putting in timesheets. This always kills people when I tell people that student athletes do have timesheets. They're like, "What?" I'm like, yeah, they have timesheets. What's that for?
Right. Well, not to be paid, apparently. In your case is saying, I mean, they're functioning like a worker, right?
Like my
is
dad
probably
said,
something
like
that-
my dad says, our case doesn't establish anything new. It just recognizes what is.
Well, Paul, thank you for joining. Thank you all for watching this interview, and please follow Sportico for more in the latest on Johnson v. NCAA.
Thanks all. Take care. Have a good weekend.